Recital 17. Regulation, EC, Number 45/2001 of the European Parliament and of the Council applies to the processing of personal data by the Union institutions, bodies, offices and agencies. Regulation, EC, Number 45/2001 and other Union legal acts applicable to such processing of personal data should be adapted to the principles and rules established in this regulation and applied in the light of this regulation. In order to provide a strong and coherent data protection framework in the Union, the necessary adaptations of Regulation, EC, Number 45/2001 should follow after the adoption of this regulation, in order to allow application at the same time as this regulation. Recital 18. This regulation does not apply to the processing of personal data by a natural person in the course of a purely personal or household activity and thus with no connection to a professional or commercial activity. Personal or household activities could include correspondence and the holding of addresses, or social networking and online activity undertaken within the context of such activities. However, this regulation applies to controllers or processors which provide the means for processing personal data for such personal or household activities. Recital 19. The protection of natural persons with regard to the processing of personal data by competent authorities for the purposes of the prevention, investigation, detection or prosecution of criminal offences or the execution of criminal penalties, including the safeguarding against and the prevention of threats to public security and the free movement of such data, is the subject of a specific Union legal act. This regulation should not, therefore, apply to processing activities for those purposes. However, personal data processed by public authorities under this regulation should, when used for those purposes, be governed by a more specific Union legal act, namely Directive, EU, 2016/680 of the European Parliament and of the Council. Member States may entrust competent authorities within the meaning of Directive, EU, 2016/680 with tasks which are not necessarily carried out for the purposes of the prevention, investigation, detection or prosecution of criminal offences or the execution of criminal penalties, including the safeguarding against and prevention of threats to public security, so that the processing of personal data for those other purposes, insofar as it is within the scope of Union law, falls within the scope of this regulation. With regard to the processing of personal data by those competent authorities for purposes falling within scope of this regulation, Member States should be able to maintain or introduce more specific provisions to adapt the application of the rules of this regulation. Such provisions may determine more precisely specific requirements for the processing of personal data by those competent authorities for those other purposes, taking into account the constitutional, organizational and administrative structure of the respective member state. When the processing of personal data by private bodies falls within the scope of this regulation should provide for the possibility for member states under specific conditions to restrict by law certain obligations and rights when such a restriction constitutes a necessary and proportionate measure in a democratic society to safeguard specific important interests including public security and the prevention, investigation, detection or prosecution of criminal offences or the execution of criminal penalties, including the safeguarding against and the prevention of threats to public security. This is relevant for instance in the framework of anti-money laundering or the activities of forensic laboratories. Recital 20. While this regulation applies, inter alia, to the activities of courts and other judicial authorities, Union or member state law could specify the processing operations and processing procedures in relation to the processing of personal data by courts and other judicial authorities. The competence of the supervisory authorities should not cover the processing of personal data when courts are acting in their judicial capacity, in order to safeguard the independence of the judiciary in the performance of its judicial tasks, including decision-making. It should be possible to entrust supervision of such data processing operations to specific bodies within the judicial system of the member state, which should, in particular, ensure compliance with the rules of this regulation, enhance awareness among members of the judiciary of their obligations under this regulation and handle complaints in relation to such data processing operations. Recital 21. This regulation is without prejudice to the application of Directive 2031/EC of the European Parliament and of the Council, in particular of the liability rules of intermediary service providers in Articles 12 to 15 of that directive. That directive seeks to contribute to the proper functioning of the internal market by ensuring the free movement of information society services between member states. Recital 22. Any processing of personal data in the context of the activities of an establishment of a controller or a processor in the Union should be carried out in accordance with this regulation, regardless of whether the processing itself takes place within the Union. Establishment implies the effective and real exercise of activity through stable arrangements. The legal form of such arrangements, whether through a branch or a subsidiary with a legal personality, is not the determining factor in that respect. Recital 23. In order to ensure that natural persons are not deprived of the protection to which they are entitled under this regulation, the processing of personal data of data subjects who are in the Union by a controller or a processor not established in the Union should be subject to this regulation where the processing activities are related to offering goods or services to such data subjects irrespective of whether connected to a payment. In order to determine whether such a controller or processor is offering goods or services to data subjects who are in the Union, it should be ascertained whether it is apparent that the controller or processor envisages offering services to data subjects in one or more member states in the Union. Whereas the mere accessibility of the controller's, processor's or an intermediary's website in the Union, of an email address or of other contact details, or the use of a language generally used in the third country where the controller is established, is insufficient to ascertain such intention. Factors such as the use of a language or a currency generally used in one or more member states with the possibility of ordering goods and services in that other language, or the mentioning of customers or users who are in the Union, may make it apparent that the controller envisages offering goods or services to data subjects in the Union. Recital 24. The processing of personal data of data subjects who are in the Union by a controller or processor not established in the Union should also be subject to this regulation when it is related to the monitoring of the behavior of such data subjects in so far as their behavior takes place within the Union. In order to determine whether a processing activity can be considered to monitor the behavior of data subjects, it should be ascertained whether natural persons are tracked on the Internet, including potential subsequent use of personal data processing techniques which consist of profiling a natural person, particularly in order to take decisions concerning her or him or for analyzing or predicting her or his personal preferences, behaviors and attitudes. Recital 25. Where member state law applies by virtue of public international law, this regulation should also apply to a controller not established in the Union, such as in a member state's diplomatic mission or consular post. Recital 26. The principles of data protection should apply to any information concerning an identified or identifiable natural person. Personal data which have undergone pseudonymisation, which could be attributed to a natural person by the use of additional information, should be considered to be information on an identifiable natural person. To determine whether a natural person is identifiable, account should be taken of all the means reasonably likely to be used, such as singling out, either by the controller or by another person, to identify the natural person directly or indirectly. To ascertain whether means are reasonably likely to be used to identify the natural person, account should be taken of all objective factors, such as the costs of and the amount of time required for identification, taking into consideration the available technology at the time of the processing and technological developments. The principles of data protection should therefore not apply to anonymous information, namely information which does not relate to an identified or identifiable natural person, or to personal data rendered anonymous in such a manner that the data subject is not or no longer identifiable. This regulation does not therefore concern the processing of such anonymous information, including for statistical or research purposes. Recital 27. This regulation does not apply to the personal data of deceased persons. Member states may provide for rules regarding the processing of personal data of deceased persons. Recital 28. The application of pseudonymization to personal data can reduce the risks to the data subjects concerned and help controllers and processors to meet their data protection obligations. The explicit introduction of pseudonymization in this regulation is not intended to preclude any other measures of data protection.